Good afternoon, and welcome to today's webinar looking at e-discovery in a proactive context. Before we start the webinar, we have a few small housekeeping points to address. To keep background noise to a minimum, we have placed you on mute. We will be responding to your questions at the end, which you can pose at any time throughout the presentation using the chat function. You can find the chat function on the left-hand side of your screen. I am Ben Pilbro. I am joined today by Hayley Pitsey and Nicola Perry. We all work in the Commercial Disputes and Regulation Division of Shepherd and Wedderburn.
Good afternoon all. As noted by Ben, this is the first of our two-part e-discovery webinar series where we will be looking at the use of e-discovery as a proactive tool. So what do we mean by e-discovery? We've coined this term to describe the comprehensive service we offer our clients to support their e-disclosure needs. With businesses increasingly relying upon and storing digital information, the occasions where we need to retrieve and review sections of that digital information, typically called data sets, are becoming more frequent. However, there is more to the process than simply extracting the data set and reviewing the data. When we review the e-discovery, when we refer to e-discovery, we include all the elements necessary to complete an e-disclosure process, including the technology platform itself, technological support, project management, legal support and analysis, and any additional assistance required.
So, to summarise in a nutshell, using e-discovery in a proactive context is a form of risk management. By taking action either before any potentially harmful event occurs or after it has occurred, but before it is brought into the public domain, companies can avoid or mitigate the potential fallout. In this webinar, we will be discussing several specific contexts in which the proactive employment of e-discovery can be beneficial. Firstly, we will be examining situations where a company suspects it has been the victim or perpetrator of anti-competitive or illegal behaviour. Here, an e-discovery review internally to establish whether there is a cause of action to bring or defend. Secondly, we will be looking at scenarios where there are employee grievances and potential employee wrongdoing within a company, and will show how e-discovery can assist with detecting bad behaviour or insider risk. Thirdly, we will be showing how e-discovery can assist in the good governance of a business. This can be important if a company wishes to demonstrate that it has good corporate governance procedures and policies in place, as a precaution against potential future contentious or investigatory situations. Fourth and finally, we will be looking at e-discovery and assisting in effective data management, focusing on document retention and destruction policies.
Before going into the finer details, it may be worth highlighting some of the general benefits of e-discovery. The past decade has seen a marked increase in the regulatory burdens falling on companies, and this has risen in line with the number of complaints and disputes they face. This is coupled with an increase in insistence by the courts and regulators that parties disclose electronic documents. Although e-disclosure has been an ingrained part of the American legal landscape for many years, it is something relatively new to the UK, and in particular Scotland. However, we have seen a marked rise in the acceptance, indeed the requirement, by the courts and regulators of the use of e-disclosure and the various techniques used to make a review more manageable. We will talk about these more in our next session on the reactive uses of e-discovery on the 17th of June. But in general, this means that companies are more likely to be dragged into e-disclosure exercises, whether they want to or not. By being proactive, having effective governance policies in place, conducting regular internal audits, and planning preemptively, companies can reduce the risk of being caught out by this trend.
Put simply, failing to prepare is preparing to fail. E-discovery offers companies an effective way to prepare and thereby mitigate the risk of being targeted by other companies, the regulators, or indeed their own employees. As we will come on to later in this webinar, the platforms and technology employed in e-discovery are very powerful. They produce ever more accurate and defensible results in cases, investigations, or audits. Our experience is that, in skilled hands, they find important details that even the most forensic manual review overlooks. They are also significantly cheaper. This makes the use of e-discovery a very attractive option for companies seeking to discharge their compliance obligations and demonstrate good governance. So, let's look at some specific situations in more detail. The first, as you can see from this slide, is where an undertaking or company believes it has been the victim or the perpetrator of anti-competitive or illegal behaviour. Consider the following scenario.
So, imagine you are the CEO of a large UK-based company whose key business is the import and resale of, say, tropical fruit. There are only a handful of other key companies in the UK who are active in this industry. Because of this, you all know each other quite well and have regular, friendly and informal chats with the CEOs of these companies about the industry. However, your in-house counsel one day raises a concern that, despite the gossipy nature of these conversations, it could be seen as anti-competitive, as you're exchanging information with competitors. Initially, you brush off his concerns, but then, during one of your chats, you discover that a group of the CEOs are meeting formally on a regular basis to discuss their pricing and targeting strategies. If correct, you think that this cooperation will be damaging your business. So, how can e-discovery be used to help when a company believes it's maybe the victim or the perpetrator of anti-competitive or illegal behaviour?
From a perpetrator's perspective, proactive e-discovery can be essential. For example, if, after a thorough audit of their system, they realise that employees have been taking part in potentially anti-competitive or illegal behaviour, they can seek early advice from legal advisors as to the best course of action. The earlier anti-competitive behaviour is discovered, the greater the options available to a company, including whistleblowing, applications for leniency, and the general possibility of reducing potential financial and/or reputational damage. However, it would not prevent the perpetrator from being brought in as a defendant to any subsequent litigation by victims of the anti-competitive behaviour.
From a victim's perspective, e-discovery can assist in analysing a company's systems for any evidence of pressure created by external bodies acting in an illegal or anti-competitive manner. For example, investigators can search for records of competitors' price increases in a company's system, or correspondence with the competitor company indicative of a cartel. Should any such evidence be uncovered by the review, this can be analysed by a legal team to assess what course the company should take against the external body, whether this be blowing the whistle on their behaviour or commencing a damages claim to recover compensation. There are numerous benefits to acting in this proactive manner. Acting before the event may prevent the company from inadvertently becoming a participant in the anti-competitive behaviour. Furthermore, taking action before any potential wrongdoing is brought into the public domain could protect the company's reputation. If wrongdoing on the part of another entity is found, it affords the company the possibility of seeking damages from the other entity should any harm have been caused by their actions.
Of course, due to the nature of illegal or anti-competitive behaviour, it is probable that any perpetrator either within or outside of the company would attempt to keep any action clandestine and off the record. It is precisely for this reason that, if a company does decide to take proactive steps to monitor for anti-competitive or illegal behaviour, it employs tools that are appropriately sophisticated for the task, such as e-discovery. So, reverting back to our scenario, let's consider some of the ways in which e-discovery could help.
From a technical perspective, it is usually simple to extract all of the documents and data from particular custodians. So in this case, the CEO, to review their contents. However, nowadays, the volume of electronically stored data generated by a normal business is enormous. Recent research estimated that an average business user is receiving 90 emails a day, which is over 22,000 a year. I would expect that our CEO receives far more than this, and this does not include other potentially relevant files, such as Word documents, spreadsheets, and digital audio recordings. It could take a veritable army of reviewers a considerable amount of time to get through this volume of data without the assistance of sophisticated searching tools.
With a digital platform, the company could manage the review with relative ease. The following are just a few examples of techniques that could be employed by the digital platform in this scenario. Firstly, using communication mapping to narrow the search to communications between the CEO and staff at the rival fruit importers. Secondly, creating a list of keywords in conjunction with the company and legal advisors to identify what the risk words are and which topics are potentially problematic. This list of keywords can then be layered, for example by searching for documents containing a word within 5 words of another word. The data set is thereafter narrowed down to documents containing those words only, being the documents that are likely to pose a potential risk. Thirdly, if the behaviour was known to have taken place over a particular period, the platform can narrow the data set down by date range to include only those communications and documents occurring within the specified date. Fourthly, the company may also choose to go down the route of predictive coding. This is a process whereby an expert reviewer manually reviews a sample from the dataset and categorizes them as relevant or not. The predictive coding software will then use the decisions made during the discrete manual review to train itself to apply the expert's pattern of categorization across the entire dataset. The database will create models, or algorithms, based on the content and metadata of the expert categorized documents, and these models are then applied across the entire dataset, categorizing all documents and highlighting those which are most likely to be relevant to the case. This can be a very effective way of ensuring consistency in review and also cutting down on reviewer time and cost.
The results of this process can then be passed on to the legal team for analysis, who will be able to determine whether there is any risk posed to the company from the nature of the relevant document. If the answer to this is in the positive, then they can advise on next steps. This may include, for example, whistleblowing on itself and the other fruit importers to the relevant authorities. This would allow the company to apply for leniency and thereby potentially avoid or reduce any financial penalty imposed by a regulator or the EU Commission. Of course, this is just one example of how e-discovery can be used in this context. It is certainly not limited to purely composition matters. Indeed, our next situation shows how diverse this technology is. You can use e-discovery to detect bad behaviour such as occupational fraud, embezzlement, breaches of duty of good faith by employees, and you can also investigate to see if any employee is passing on confidential or sensitive data, such as email addresses, telephone numbers, and credit card details to third parties in breach of data protection laws. You can also use it to investigate complaints of harassment and bullying in the workplace. Being proactive in this context can alleviate the risk of either losing out due to employee misdemeanour or being accused of failing to properly protect your employees.
In addition to the techniques we have just discussed, there are some specific tools that can help in this context. For example, there is a new technology which is designed to help proactively identify potential insider threats that could be lurking within an organization. Once data has been extracted from a company's system, the technology uses the science of psycholinguistics to analyze digital communications over a length of time, and it registers notable changes in emotions, attitudes, and personalities, which may not have been detectable by human review. The technology thereby identifies the employees most likely to be a potential threat to the business. Of course, companies should always be aware of any data protection issues and internal policies, in particular if there is a desire to examine an employee's personal accounts. Legal advisors can assist in this respect and advise on any limitations to the proactive review, whilst also advising on any resultant findings. We won't, I'm afraid, go into any further detail on this section, as John Schmidt, a partner in our competition team, has recently given a well-received webinar on detecting bad behaviour specifically. It is available on our website for any of those listening today who may be interested. The link is shown on the slides here.
Now, moving on to a topic that affects all companies, and that is ensuring good governance of the business and workplace. As we emphasised earlier, given the increased scrutiny of companies by regulators, financial authorities, and indeed competitors, it is very important for companies to be able to demonstrate they have the correct policies and procedures in place to ensure compliance with the law. Appropriate policies are both preventative and curative. They reduce the risk of a breach occurring in the first place, but should a breach occur, they assist in mitigating the responsibility and costs to the company. Of course, good policies and procedures can tie in with the detection of insider threats. To examine this in more detail, please consider the following scenario. You are the chief executive of a large construction company. You receive an invitation to tender for a large council project. You put your two best bid contractors on the case. However, after weeks of work, they come back empty-handed, as the contract was awarded to a competitor. You are surprised, as the project was exactly in your company's area of expertise, but you would dismiss this as bad luck. Some weeks later, you receive a telephone call from the council accusing your company of rigging the bid and accepting bribes from competitors to deliberately lose out and allow the competitor to charge exorbitant prices. So what do you do?
Before considering this scenario in more detail, we should consider the general potential of using e-discovery in this context. E-discovery can be used as a means of stress testing a company's governance and compliance procedures. For example, the electronic review platform, in conjunction with the legal advisors, can take on the role of regulator or court to conduct mock-at-dawn raids and audits of a company's data and documents. The legal team will then analyse and review the strength of a company's compliance policies and help determine any weaknesses and loopholes that need to be closed. This support can continue for the duration of the company's relationship with the e-discovery provider. The legal team can keep the company informed of their current compliance obligations and employ the review platform to retest the company's systems as and when needed to ensure they are up to date with compliance. On the back of these reviews, the legal team can assist with training. It can draft compliance manuals and thereby assist the company in strengthening the system of internal governance. This can be very important. If, for example, a company faces a bribery or corruption accusation, having a strong anti-bribery policy and training regime in place can alleviate the risk of liability in respect of such offences. This would pass only to the individual or individuals who took part in the action.
This neatly brings us back to our scenario. Let's consider some of the ways e-discovery can assist here. You, as CEO of the company, are now concerned that you have a potential issue with accusations of bribery, which you fear will lead to serious fines and significant reputational damage. Given your own suspicions at the time the tender was lost, you do feel uneasy. So what do? Our e-discovery team can assist in a multitude of ways. As mentioned, they can analyze your system to test the effectiveness of the anti-bribery policy. An anti-bribery and corruption policy will only be considered effective if its rules are clear, practical, accessible and effectively implemented, and enforced. It is also given more weight if it has been risk assessed and well communicated across the company. Continuous monitoring for compliance and periodic review also give further credence to an anti-bribery policy.
An internal audit can be undertaken to assess compliance with the company's anti-bribery policy, perhaps also assessing if the company has been the victim of bad behaviour at the same time. On a more general level, our e-discovery team can assess how effectively the policy has been communicated across the company. We can also assist in assessing the information brought to the fore by the internal audit and consider whether the policy is, indeed, clear, practicable and effectively implemented. The team can also assist in providing training across the company and strengthening the policy. This has the effect of both mitigating the risk of a breach of bribery law and, should a breach occur, mitigating the risk the company itself is held liable. Therefore, if, as in our scenario, your company is in an industry at risk of bribery or corruption, e-discovery can be an effective way to ensure you have proper policies in place and avoid potentially grievous penalties.
And that brings us on to the last situation we are going to look at today in detail, that being how e-discovery can help in data management. Consider this final scenario. Imagine you are the director of a holiday insurance company, receiving thousands of customer details on a regular basis. You store all of these details, including names, dates of birth, bank credit card details, and information concerning specific claims, including medical records, on your internal systems. You continue to hold this information even after a customer has finished using your services, or the details are deemed redundant. This could be considered a retain all data management policy, which is considered by some companies to be the safest course of action. However, now consider what would happen should your company's system be hacked, or you become the victim of an aggressive virus. Before considering this scenario in more detail, let us have a look at data management more generally.
Effective data management can be extremely important. Having an effective document retention and destruction policy is beneficial, for example, because it reduces the cost and space required in a retain-all policy. There are, of course, different requirements for data retention across different sectors and jurisdictions. For example, with the implementation of the hotly debated and snappily named Data Retention and Investigatory Powers Act, also known as DRIP, some telecoms operators may be obliged to retain customer records for up to 12 months, which could be a very high volume of data. Of course, all companies must abide by these statutory and regulatory requirements. However, there are various data management options for businesses not affected by such restrictions. We will do a brief run-through of some of the key advantages and disadvantages of 3 of the most commonly employed data management systems.
First would be the retain all policy, which pretty much does exactly what it says on the tin. In taking this approach, companies consider there is no risk of accidental deletion, which can lead to legal issues down the line. However, it takes up a huge amount of computer space and, importantly, IT management, costing time and money. There is also a higher risk if the system crashes or is hacked, as lost data can lead to large fines if you are considered to be the custodian of the said data. Storing more data than is required can lead to heavier losses and heavier fines. For example, in a case not dissimilar to our scenario, an insurance company was fined £175,000 for having lost credit card details to a malicious software virus. The level of the penalty was more severe due to the fact that the company had retained old credit card details of past customers, even though many of them were from expired cards and accounts. Furthermore, it can also be harder to locate the information needed or to know what data has been lost or stolen. Another option is the user retention policy, whereby users are responsible for their own data deletion, albeit with guidelines in place. These guidelines will be bespoke to the specific organisation. However, it risks user error and is unpredictable. It can also be a drain on IT resources, who have to train and monitor users. The final option considered here is the fixed period policy, whereby data is automatically deleted or archived after a certain amount of time. This is a secure system and avoids the unpredictability of the user retention policy, but there is a risk that certain information, for example, information stored locally on a company computer, may not be deleted effectively, and other information may be negligently deleted.
So, how can e-discovery help in testing whether a data management policy is robust and appropriate for the company? The e-discovery team can help identify the risks to each individual business and, whilst considering any requirements for the business, help create an effective data management policy. This will include creating document retention and destruction policies and designing any relevant legal and litigation holds that may need to be put in place. Through e-discovery, a company will be able to thoroughly analyze just how much data it currently holds and will be able to stress test any new policy to ensure its effectiveness. It is also worth noting that, in addition to assisting with internal data management, e-discovery can assist when examining another external company system. A key example of this is in a merger and acquisition context. Typically, a prudent business will conduct thorough due diligence of a target company system before proceeding with any M&A. E-discovery provides a convenient way to do this, as it can be done across borders, across reviewers, and can assist a business in seeking out exactly the elements of the target company system that they are interested in. This is yet another context in which proactive e-discovery can be a boon.
Let's return to our scenario. For a company such as a travel insurance agency, holding such a volume of personal data for its customers poses a serious data protection risk. Having identified this, the e-discovery team can stress test the retention policy by taking on the role of a hacker and stealing a sample of data. If, upon legal analysis, it is shown that the company would be in a serious breach of data protection laws due to holding personal information when it should have been destroyed, i.e. the details are redundant or the individual is no longer a customer, then the agency should revise its policy or it risks breaching data protection law. In conjunction with its legal advisors, the company could reform and revise its policy before any damaging event actually occurs. The company can repeat the process on a regular basis to ensure that it is being enforced across the business.
And with that, we have finished our whistle-stop tour of the potential of proactive uses of e-discovery. We hope that you have discovered some new and innovative ways in which to employ this ever stronger and advanced technology to risk manage in a proactive context. It is worth emphasizing that each of the scenarios discussed today are based on real-life matters in which the company faced severe financial penalties, failing to prepare and organize their business properly and effectively. E-discovery is an efficient and effective way of mitigating this risk.
As Nicola mentioned, we can now conclude today's webinar. I note that we have received a number of questions on the chat function. We'll be responding directly to them. If you do have any further questions, please feel free to type them now, or alternatively, email me, Ben, or Nicola. Before we leave you, can I just thank you all for attending and remind you that our next webinar in this series on the reactive uses of e-discovery will be on the 17th of June. We hope that you can attend.